All right, we do have two guests tonight, and so Jolene Kramer's here from, I'm just going to say David Rosenfeld's office, because David Rosenfeld's like the premier labor attorney in the state of California, according to
You don't need to know the other guys, yeah.
And Ingrid Brunstrom from UC Merced Community and Labor Center is here to talk about community benefits agreements, which are similar, adjacent, but different. So first up, just want to welcome Jolene Kramer, who drove from San Francisco today through the storm to get here.
Yeah. It was really not bad. I told Dylan I had sunshine the whole way, so it was all good. And our firm is based actually in the East Bay. We originally had an office in San Francisco way back. The firm's been around for over 50 years. Slowly moved to Oakland, then Alameda. Now we're in Emeryville, so kind of migrated that way as rents got higher, but also as our clients moved to other places too. Kind of, I think, along the lines of a shift toward, unionization among working class folks. We want to try and make sure that we're accessible to our clients. And San Francisco is not all that accessible anymore. So we're out in the East Bay. We also have offices in Sacramento, LA, and Vegas is our newest office. We have attorneys who are barred in Hawaii, in Oregon, in Arizona. I think we might even have one in Wisconsin or something. So we try and have as much of a national presence as we can, but our home is California. So I'm here to talk about project labor agreements and community workforce agreements. And you all do have this presentation printed out. Hopefully it was printed with some ability to take notes if you're interested in doing that. Also, if you have questions, like a clarifying question on a subject, feel free to raise your hand. I understand questions come up as you think of them, so no need to hold those off. If you have a longer, more detailed question, you're dealing with a particular issue around a project labor agreement, something of that nature, let's hold that for the end. I will have time at the end. I'm not sure how long this presentation will go. It is a little bit long, so I'm going to try to make it as entertaining as possible. But there will be time for questions at the end, and I'm happy to talk to you about whatever specific questions you have around these things, because I know that they're sort of unique animals. They're, you may not have really encountered a project labor agreement before, and some of the language in these things is somewhat esoteric, somewhat, carried over from years and years and years. And so I get that, the ins and outs of them can be a little bit complicated. So I'm happy to answer whatever questions you have, and there will be time at the end for that too. All right, so I wanted to get a sense first of who is in the room here. So who is an elected official or staff member of an elected official? Okay, good. Fair amount. Great. Okay. And then of those who are either elected officials themselves or staff persons, is there anybody who currently sits on the board of an agency that has entered into a project labor agreement before? We've got one. Okay, great. And what agency is that?
State Center Community College.
State Center. Okay, great.
Just last week, by the way.
Oh, okay. Well, yeah, and then my understanding is that it was a vote to negotiate an agreement, is that right?
Right, so
okay.
we've entered into an actual PLA for projects
for a previous.
Center,
yes, okay.
College. And then just last week, we passed a resolution to enter into negotiations to establish a district-wide PLA.
Great, love to hear that. Okay, great. So I hope that means your experience was positive. That's what we try and do with these things. We try, where there's some hesitation, like to your question about how we can get more of these. Sometimes agencies want to do like a pilot, want to just have a PLA that's specific to a specific project, and that's typical. But the idea being that if it goes well, and if the agency is happy with what the building trades have been able to do on the project, that they would entertain the idea of a policy that actually applies to multiple of their projects. And usually, and we'll talk more about that, those usually have a term of years. Anybody have any other experience with project labor agreements?
say that it was less than 12 years ago when project labor agreements were illegal in Fresno County. And I bet most people didn't know that either.
Oh, I did not know that.
We have to talk about from that time when we get to Q&A, but that is one experience we should know. We're one of the only counties in the United States that we're illegal to have project labor.
Interesting. Yeah, no, there is now a state law. That's so interesting you bring that up. There's now a state law that says that cities and any public agency has the right to enter into a project labor agreement, provided that it has certain components, which in the statute, they're called taxpayer protections. But prior to that, that's right. Localities, counties, in most cases, passed these laws that actually prohibited them. Is there anybody here who's considering running for office and wanted to get more information about PLAs for that reason? Great, wonderful, okay. Anybody who's a representative from a labor organization? Yes, okay, a few, okay. Who did I miss? Just community members that are passionate about project labor agreements? Okay, good. What was that?
I heard Jolene.
Yeah.
And sorry, I think I might have missed it, but for the first bullet point, I just want to introduce myself.
Oh, sure.
I'm Myra Kemba, and I work for Councilmember Annalisa Freya. So my main job duties are to work for, all of our road paving projects, concrete projects, and we'll be working a lot with the PLA mentioned.
So City of Fresno council member. Okay,
Yes.
wonderful. Yeah.
So it expires in 27, and
Yeah.
we're going to extend it past that for sure.
Yeah. That was a great victory, honestly. I feel so fortunate to have been part of that. It was really an interesting, dynamic experience. As the attorney for the building trades, yeah. My first project for them, actually, I think was the Fresno citywide agreement. And it was great. So much participation. Your council members were very engaged. It was a really good experience. Okay. Well, this is the million-dollar question. What is a project labor agreement? So I always refer to it as an umbrella collective bargaining agreement between an owner of a project. We're here talking about PLAs on public works in most cases, although I'll talk about PLAs that apply to private development as well. But it's a collective bargaining agreement between an owner of a project, often a public agency, and local building trades, typically the Building Trades Council, that applies to either one project or a whole set of projects. So historically, from the very beginning, like the Hoover Dam was built under a PLA. From the very beginning, they were conceived of as labor agreements, master labor agreements for large infrastructure projects. Over the years, though, that has evolved, especially as courts have approved these things in other contexts. So now we negotiate a lot of agreements that are policy-wide for an agency, like a citywide agreement like we have in Fresno, a school district-wide agreement like we're hoping to get for Fresno USD. We can do agreements that have a list of projects that they apply to. So there are different iterations of this, but this is the general definition. It is, and I'm sorry to have to do this to you, but we are going to talk about the law, National Labor Relations Act in particular, and so just as a preface to that, it's important to know that project labor agreements are considered pre-hire. You may have heard that term before, pre-hire collective bargaining agreements, which are allowed under the National Labor Relations Act, specifically Section 8F. And that's because it's entered into between labor and management without a showing of majority support. So in the general unionizing context and organizing context, what do? You try and get majority support among the workforce for the union. And you might do card checks, you might do an election, but in the end, the union is showing majority support and then their employer has to recognize them, right? We get an exception from that in the construction industry. In the construction industry, a union and an employer can enter into a collective bargaining agreement together without a showing of majority support, okay? And that's what these are. They are understood as project management tools used to reduce risk to the owner and they allow the owner to construct proprietary projects, that's a word we'll come back to in a second, without delay, using skilled workers residing in the local community. A main attribute of PLAs is a commitment by the unions who represent the workers to labor peace and no work stoppages, even if they're otherwise on strike. So strikes are actually more common nowadays, right? They didn't used to be very common, but now they are. And a lot of unions have been going on strike, as I'm sure you all know. So when there is a project labor agreement on the project, the unions that have signed that project labor agreement have actually agreed that even if their union is on strike, their members will go to work on the PLA project. That's why they're understood as labor peace agreements, okay? So there's a no strike commitment. There are no strike commitments in collective bargaining agreements too, but most of the time when unions go on strike, it's because their agreement has expired, they're in negotiations, and they can strike when their agreement is expired until they get a new contract, right? If you have a PLA on your project, then even if there's a picket line, the instruction to the workers is you gotta go to work, okay? So it is a powerful tool in that regard. Okay, the project labor agreement will commonly, and I mean it always will, incorporate collective bargaining agreements of the unions, but it overrides them if there's a conflict. So if there's a term of a PLA that's different from a term of a collective bargaining agreement, by signing the PLA, the union has agreed we're modifying our collective bargaining agreement to the extent that there's any conflict or inconsistency. It also provides for compliance with public works laws and wage and hour laws under the labor code. As you all know, I'm sure, public works projects require payment of prevailing wage. That is facilitated by PLAs. PLAs also discourage wage undercutting. They lift up construction workers in the local community through the local union dispatching the workers on the project, and also sometimes local or targeted hiring policies, and we'll talk a little bit more about that later. They also require pre-job conferences. And at the pre-job conference, which is different than the pre-construction conference, sometimes, like if those of you who work for a public agency, you might be familiar with pre-construction conferences, which are basically just meetings that the owner will convene either before or after a project is awarded, where all the contractors on the project talk about, the plan. This is different from that. This is a unique labor meeting where all the contractors actually assign the work. They say, this union's doing this, this union's doing this, this union's doing this. Everybody understands who's doing what on the project so that it runs smoothly. And it's actually a very important tool for the efficient construction of the project. This is an important point as well. Under state law, if a PLA applies to a public works project, any contractor can work on that project regardless of union affiliation, okay? You hear about PLAs talked about in the context of like union versus non-union. That's a fallacy. Any contractor can bid for and be awarded work on the project regardless of whether they're signatory to a union. If they're a non-union contractor, then they get dispatched their crew from the local hiring hall. That's how that works. I just thought it would be helpful to understand at the outset what is the process of execution once we actually negotiate the agreement. The first step is that the agency would approve the agreement. Then we, as a building trades council, get approval of the PLA from our national organization as well as our affiliates, although honestly, during the course of the negotiation, we're getting feedback from everybody and making sure that there's no issues with the agreement. The public agency and the building trades council execute the agreement. That's what makes it effective. Then we have the unions that sign the agreement on a separate signature page. And then the contractors that come onto the project, they sign what's called a letter of assent or an agreement to be bound. That's a form agreement that's attached to the back of the document, and every contractor on the project must sign that agreement, and by virtue of doing so, agrees to the terms of the PLA. Okay, community workforce agreement. So a community workforce agreement is just a type of PLA, okay? They're not different. I know there's community benefits agreements, which we're gonna talk about a little bit later, which are slightly different. And sometimes PLAs get called community benefits agreements, even though they're more like PLAs. We get a little loose with the names, you know, and it really kind of depends on like what are the priorities of the agency too. I think our Fresno one is well, no, it is a PLA. Yeah, it is a PLA.
Our state center one is specifically
Is it
project labor and community workforce.
and community workforce?
We want to emphasize these things here.
Yes, exactly. And that's exactly my point. You know, it really kind of depends on what the agency wants to emphasize and what kinds of additional terms we might be including that deal with workforce development, right? So a community workforce agreement is a type of project labor agreement particularly focused on apprenticeship, workforce development, construction training, and growing the local pool of skilled construction workers. A community workforce agreement can target residents of specific areas, for example, specific zip codes, or individuals with certain characteristics. I've done agreements that will target graduates of local pre-apprenticeship programs, perhaps folks that have been involved in a foster care system or who were formerly incarcerated, things of that nature. A CWA can also incorporate pre-existing policies of the public agency. So if the agency, and I don't know how common this is in this area, it might be, but I often deal with agencies that have their own local hire policy, for example, for city contractors, construction and non. They may have their own targeted goals as far as residents coming to work on their public works projects. So we would incorporate those into a community workforce agreement if they exist. If not, we can put them in the workforce agreement, community workforce agreement. We can just put the goals in our PLA. For private projects, so there are PLAs on private projects, and in those cases, sometimes the owner is subject to local municipality goals or requirements for employing local residents or other targeted workers. And if so, we would incorporate those into the CWA as well. That's often going to be put in the development agreement. So, you know, sometimes a local agency will require, incentivize a project labor agreement for a private development project. And that would be put often in the development agreement. So for private projects, we also discuss how the owner, also all the contractors on the project can promote workforce development while also adhering to the commitments in the CWA. And sometimes we have to draft unique language in that regard. So sort of along those same lines, there are two types of PLAs. This is just my interpretation. It's not like this is necessarily something you would read anywhere, but this is how I approach these agreements. Public style and private style. Public style PLAs are with, who has a guess? Public agencies, very good. Public agencies like cities, counties, and school districts. Private style PLAs are with developers, very good. Private entities like developers, sometimes general contractors. So often we'll do deals with the general as opposed to the developer, but they're done both ways. Public style PLAs, which are with agencies, cannot be limited to union contractors, and that's because of our state competitive bidding laws, okay? PLAs with public agencies are legal in all 50 states and the District of Columbia. The major case is the US Supreme Court case that you may have heard of. It's called Boston Harbor. In that case from 1993, the Supreme Court held public entities have the same right as private owners. So this gets to your question about like what are the outer limits of what an agency can do. They act as private owners, and they can enter into project labor agreements as a tool for the effective construction of their public works projects. Similarly, the California Supreme Court, in a case handled by my colleague back in 1999, The California Supreme Court held that PLAs are consistent with our California competitive bidding laws because they do not bar or substantially discriminate against a class of contractors, and they further legitimate government interests. So we have a federal Supreme Court case saying that PLAs are illegal, and we also have a state Supreme Court case saying that PLAs are legal. Benefits to the community. These are the overarching policy reasons why these agreements make sense for local agencies. Responsible use of public construction funds, employment of local residents, apprenticeship training for local residents, retention of middle-class jobs in your own communities. Jobs to veterans through helmets to hard hats, which is I'll talk about later, has to go in every PLA. Health benefits for workers and their families, implementation of clear safety protocols, and projects completed on time and on budget. There's more benefits. PLAs include no strike, no lockout clauses. I talked about that. Commitment to no strike or slowdown or work stoppage of any nature. They also facilitate dispute resolution through arbitration. They ensure that local tax and bond dollars benefit the local economy. They attract quality and ethical contractors. PLAs result in stable and well-paying jobs that contribute to a prosperous tax base. And PLAs allow the public entity to innovate new programming to introduce residents to middle-class careers in the construction industry. This is a slide on union apprenticeship. So PLAs do require that apprentices be enrolled in union apprenticeship programs. And there's good reason for that. Union apprenticeship programs provide very comprehensive, very high quality training. Most programs are 4, if not 5, all programs are 4, if not 5 years. So it's like college. It's even longer in some cases. They provide for a lifetime career rather than somebody who just works in and out of construction. They also provide for a true living wage. You earn as you learn when you're in a union apprenticeship program. So you work for a contractor during that time, and then you have classroom hours that you also have to satisfy. But it's a job from the very beginning. Also, collective bargaining rights, health and welfare benefits, and pension benefits, those things that we know that unions provide. Union apprentices train in more crafts and have higher completion rates. They graduate more women and people of color. And graduates are financially stable and therefore less likely to use the social safety net. Helmets to hard hats. So this is a national nonprofit that's sponsored by unions and contractors associations, and it connects transitioning military service members with career opportunities in the trades. It's actually a nonprofit that was set up by our national organization, the National Association of Building Trades Unions, which is the construction department of the AFL-CIO. Every PLA includes a requirement that contractors and unions work with helmets to hard hats, and this is a prime example of the potential for social justice and innovation provided by PLAs. Okay, so we're gonna talk about the law a little bit here. So the National Labor Relations Act is a federal statute. It was passed way back in 1935. It gives workers the right to organize and engage in protected concerted activity. It applies to workers in the private sector, okay? So the rights of public sector workers, those are in state law. So even the right to organize, if you're a public sector worker, that's in our California state law. The National Labor Relations Act does not apply to workers that work for government agencies. The NLRA addresses the right to form or join a union or not, the right to bargain collectively, the right to strike and picket, and the right to engage in other concerted activity for both union and non-union employees. It also requires unions to represent bargaining unit members fairly and in good faith. And you may know that if a worker is in a bargaining unit, even if they have decided to opt out of their union dues, which they can do in the public sector, or if they've decided to opt out of certain payments, which they can do in the private sector, the union has to represent them anyway, because they have to represent everybody in the bargaining unit. Okay. 8F, I mentioned this earlier, it authorizes pre-hire collective bargaining agreements in the construction industry. And as I said earlier, it's an exception to 9A, which is the section that requires a showing of majority support. There's also section 8E that's referred to as the construction industry proviso. It basically allows for subcontracting limitations. It allows in construction industry employers only to enter into an agreement with a union that says, I'm going to bind all of my subcontractors to this agreement as well. And that's what a PLA does. So a PLA, basically, we enter into it with the owner or with the GC. The GC, by signing the PLA, is required to pass the obligation down to its subs, and then its subs are required to pass that down to their subs. And that's how it works to make sure everything is covered. And that's only allowed in construction. Otherwise, it's illegal. They call them hot cargo agreements. Okay, so now we're getting into something called NLRA preemption. It's very important because it's the basis for the legality of PLAs, but it's also rather legally complicated. So you have the presentation. I'm going to go through it, maybe make a little bit quickly. If it ever comes up for you, maybe reach out or refer back to the presentation, because I do think that these are pretty fundamental concepts that anybody who's entering into a PLA should know. So there are two things that the NLRA preempts. In other words, the NLRA prohibits an agency from imposing any kind of regulation, entering into any contract, doing anything, taking any action that does these two things. So a local agency cannot pass a law that regulates conduct that the NLRA arguably protects or prohibits, and cannot enter into, okay, I don't know how to get rid of that, but anyway, hopefully it'll go away. A law that interferes with the fair play of economic forces. And that's referred to as machinist preemption. We already talked about the Boston Harbor case, which is where the Supreme Court was squarely faced with the legality of PLAs. It was based on the actual reconstruction of the Boston Harbor. So the Massachusetts Water Resources Authority required a PLA for the Boston Harbor cleanup project. And that was challenged under a theory of NLRA preemption, which I just went over. And in 1993, the Supreme Court held the NLRA does not preempt government action where the government is acting as a market participant, that's the language, rather than a regulator. In other words, the NLRA and other federal laws preempt regulatory action only. Ever since Boston Harbor, many state and local government policies have been upheld on a market participant basis in the PLA context and beyond. And on the flip side, the market participant exception has been invoked to defend policies preventing PLAs. So just like you can require one, you can prohibit one based on this theory, okay? So the market participant exception is only an issue when a public agency is adopting or imposing a PLA requirement. In order to impose a PLA requirement, the agency has to have a financial or proprietary, what we were talking about earlier, interest in the efficient construction of the project. Blanket policies like a citywide agreement or an agreement that applies to multiple projects are okay as long as there's a sufficient proprietary interest. A PLA requirement can be implemented through an ordinance. It can be implemented through a contract. The form really doesn't matter as long as the test is satisfied, which is that it addresses the proprietary interests of the agency and is tailored to addressing those interests. The market participant exception also applies in contexts where an agency is adopting or imposing a PLA for a private development. So getting to the discussions that we've all had already about what you can do as agencies for private development, this is the outer limit. You have to have a proprietary interest because you have to fall under this exception to NLRA preemption. Hopefully I haven't totally bored all of you. But that's how it works. So basically, federal law says you, City of Fresno, you cannot impose a PLA requirement, okay? Unless you are actually acting like a private owner. And you're exercising your proprietary interest, your financial economic interest in the efficient construction of the project. And in that way, you're acting really like a private owner. You're not acting like a regulator. You're acting as a proprietor.
How does that work though if all of our projects are all public, right? Public streets, public
Yes,
sidewalks?
but you own those things. So you get to say, as the owner of these streets and as the owner of these sidewalks, I want a PLA because I think it's going to result in efficient construction. That's the basis. Yeah, but that's good to make that connection. Yeah, for sure. A public agency can adopt or impose a PLA requirement on a private development if there's a proprietary interest in efficient construction. We just said that, and that's often done in a development agreement. Okay, so we did talk about this a little bit, but just here. See if I can get this out of the way too. Okay, move that maybe down. Okay. So first, typically the Building Trades Council makes contact with an owner, whether they're a public agency, a private contractor, private owner, general contractor, or when appropriate provides them, and when appropriate provides them with an opening proposal. Sometimes agreement terms are discussed before a draft is prepared. Sometimes, like State Center, there's actually a vote to negotiate. That's actually pretty common. It's not required, but it's helpful because otherwise, sometimes staff doesn't necessarily feel like they have the authority to negotiate, or perhaps they don't have the requisite parameters. So often and because the building trades are engaging with the elected officials directly, the direction has to come from the elected officials. Hey, sit down with them, work out this agreement, right? So there are often votes to negotiate, and that's very, very helpful. It's not required. And then we will provide an opening proposal, the name of the agreement. Oh, sorry, yeah.
Yes, so if it's common but not required, how would an agency just start negotiating automatically?
If they don't vote to negotiate in a public meeting, yeah, they can just, depending on whatever their internal process is, direct staff to negotiate with us. And sometimes we can have like one elected official who's actually participating in the negotiation process. It comes back for approval, right? Yeah.
So you wouldn't necessarily need a majority of your public agency's governing board to do that? You just should?
I would say that really depends on your own local laws, practices, legal advice. Yeah. Mm-hmm. The name of the agreement would depend on the circumstances. We can call it a PLA, Community Workforce Agreement. Sometimes you see Project Stabilization Agreement, Community Benefits Agreement. The parties would be the owner, which is often the agency, and then the Building Trades Council, also the unions who sign on to the agreement, and the contractors who perform work on the project. And sometimes, as I said, the agreement is with the general contractor rather than the owner. Sometimes the Building Trades Council will have a whole negotiation team comprised of various union representatives. And sometimes it's a small group that's just the head of the building trades and their attorney. So that takes all sorts of different forms. As I said, we've even had negotiations with electeds. There's, of course, Brown Act concerns, right? But that has happened as well. Much of the language in these agreements is standard, but there are areas where the specific desires of the owner can be discussed. And if an issue comes up that affects a craft that's not at the table, then the Building Trades Council, the folks who are in the room from the trade side, are going to contact that craft for consultation. The idea being, by the end of this process, we feel extremely confident that this is an agreement that all of the trades will sign on to. Once a PLA is negotiated, If it's with a public agency, the agency approves the PLA at a public meeting pursuant to its local procedure. Building Trades Council that gets approval from the AFL-CIO Building Trades Department. We execute it, the public agency executes it, that's what makes it effective. Unions sign on a separate signature page, and then the contractors sign an agreement to be bound. As they come on, they don't sign it until they are hired for the project. Pre-job conferences. Every PLA contains language providing for a pre-job or pre-construction conference to take place before work commences. It's the obligation of the owner to make sure these conferences happen. They're often run by the Building Trades Council, but the way it's written, we do like to put the obligation on the owner because the owner is really the one controlling the project and who can require contractors to show up to these things. There may be a standard form, and that's to help with workforce projections, staffing projections, especially if it's a non-signatory contractor doing the work. That way the union who will be dispatching the workers knows how many people they're going to need. Yes?
Can you explain what a non-signatory contract?
Oh yeah, just a contractor that's not entered into a collective bargaining agreement with a union. Yeah, so as I said earlier, on a public works PLA, those PLAs have to allow for non-signatory contractors to participate on the project. And so in that case, the contractor could be awarded the contract and then they go to the union, and that's what the pre-job is for. They make contact with the rep from that union, and they have a conversation about what the staffing needs are gonna be. They request dispatch for the project, and then the union will dispatch their members or their folks on their out of work list to that non-signatory contractor because there's a PLA. If there were no PLA, then the union would not dispatch to a non-signatory contractor. Yeah. The primary purpose of the pre-job is for contractors to make work assignments and the crafts to understand the upcoming work. As I said, it's also a forum for non-union contractors to interact with the reps. And we do consider pre-jobs to be a major benefit of PLAs. This is like really where the efficiency gets implemented. Everybody understands what union is responsible for what scope of work, what classifications apply, what everybody's gonna get paid, and there's a dialogue that's established between the contractors and the reps so that we all make sure that it's staffed correctly, efficiently, and the project is done on time. Right, Jeff? Yes. Sorry, was there a question? Yeah.
Can you clarify again, who's the one that chooses which unions the project goes to? Is that the contractor?
That's the contractor.
Or not the owner?
Not the owner.
Okay.
Yeah. I mean, the owner has some obligations under state law to specify the prevailing wage that will have to be paid. But as far as what union gets assigned the work, that's at the discretion of the contractor. And PLAs contain jurisdictional dispute provisions. I don't know if I have a slide on this or not. But what that says is basically, if you take issue, if your union takes issue with how work is assigned under a PLA, you can't take any action on the project. You have to go through a special procedure that is set out by the national organization, by NAB2. And you can run it up that flagpole however you like, but work will not stop on our project. So there's a definition of covered work. It's generally defined as the union collective bargaining agreements, the work that is covered under the union collective bargaining agreements. There's a requirement to pass down the PLA to subs, as I said, and that's done through the letter of assent or agreement to be bound. There's incorporation of the collective bargaining agreement, so the PLA will apply if there's a conflict, but otherwise the CBA terms will govern. There's no strike, no lockout, expedited arbitration if there is an issue in that regard, but in my 10 plus years of doing this, I've never seen that. There's union representation and referral. So the unions are the exclusive bargaining representatives. They refer all workers to contractors for the project, and the hiring hall rules apply. Yeah.
Is there any kind of amendment process built into this, and then what does that kind of look like?
So there's not usually a special process. Sometimes there's language saying this agreement can only be amended by the agency and the Building Trades Council. But otherwise, just regular old contract law would kick in. So like any contract, the parties can amend it. And that can be done. I would say that depending on what the request is for amendment, if it's something minor, it's usually a non-issue. We would agree to something like that. If it's something like, oh, this massive project that we initially thought was going to be under this PLA, we want to take it out, then that's a different conversation, right? There's job site access provisions for the union reps. Wages, benefits, shifts, stewards, other working conditions can be included. They can also just reference the collective bargaining agreements, so the terms that are in the CBAs will apply. There's language regarding apprentices. They're referred from the appropriate joint labor management program. There's also the potential for incorporation of local pre-apprenticeship and other workforce development programs. There's a grievance process, mandatory final binding arbitration. That way we promote efficiency. There's pretty quick timelines for this. The idea being we don't want grievances on PLAs at all, and if they are going to go to arbitration, we want that resolved as soon as possible. There's the jurisdictional dispute procedure that I had just mentioned, which NAB2 has form language that it requires in all PLAs that incorporates their national plan for the settlement of jurisdictional disputes. And then the term of the agreement. This is actually pretty important. I know this is getting long. But if you have a PLA that's like a district-wide PLA or city-wide PLA or what have you, agency-wide PLA, instead of identifying projects, it will just have a term of years. So say, what's our city one is 5 years, yes? 5 years, okay, yes, 5 years. So it's a 5-year agreement. It's all projects over $1 million within that 5 years. And at the end of the 5 years, either party can terminate it or it can be extended. It can also be modified. But that's how it works when you do a policy that applies across the board to projects over a certain dollar amount, which is pretty typical. If you do a list, or if you just have a PLA for a single project, the PLA ends when those projects end. And that's a different model. So I have slides in here on the Biden executive order. We have a different president now. So just making you aware that this does still exist. It is still in place. It's on life support, but it's there. So there is a federal policy requiring PLAs on projects over $35 million, but only on federally contracted projects, okay? Not federally funded projects, just federally contracted projects. What I've seen is a lot of military contracts, things like that. There are also federal laws that require or incentivize PLAs. The Bipartisan Infrastructure Bill, the Inflation Reduction Act, like Biden's two big economic pieces of legislation, and also you may have heard of the CHIPS and Science Act. All three of those have PLA incentives, but not requirements. This is a picture of President Biden signing the executive order. It does state that it is the policy of the federal government for agencies to use PLAs in connection with large-scale construction projects to promote economy and efficiency in federal procurement. So it goes back to this whole concept of financial interests, efficient construction. And that is all from that Boston Harbor case that established the market participant defense to federal preemption. So just like the city of Fresno or State Center, the federal government is able to do this because of its proprietary economic interest in efficient construction. Okay, I did already talk about a lot of these things, so I think we'll just kind of buzz through them. Optional for lower value projects, but not required. Optional for projects receiving federal funding, but not required. It did require certain terms to be in the PLA, including that non-union contractors can participate. That's what that last bullet point says. All contractors may compete for contracts regardless of whether they are union signatory, and that has to go in any federal PLA. It revoked the existing Obama executive order too. Yep?
Are there
That's a good question. So regs on this were published at the very end of 2023. So sadly, it was really only in effect. I mean, there are not very many projects to which this applied before Trump got elected. But once the regs were published, and this was in the executive order itself, but the regs fleshed it out a lot more, the agency can actually grant an exemption based on certain factors. So it requires the agency to make an assessment about whether or not a PLA would be prudent. They do this through a public website, same public website that advertises the project. So that would be where, any publication of these contracts would come from. It's called sam.gov, if you feel like some nighttime reading. Yeah. Oh, it's awful. Have you tried to go on it? It's awful.
No, I signed up for it.
Did you? It's terrible. And they do that on purpose. We used to have a really efficient system, and
It was.
I'm not sure why that changed. Yeah. Go ahead.
Can you repeat the website?
sam.gov, sam.gov. It's their federal procurement website. They actually changed it when Biden was still in office, and I don't know why, but certainly recently it's gotten a lot harder to navigate. So there's some factors that they have to consider, whether it would advance government interest in achieving economy and efficiency, whether market research indicates that imposing a PLA would reduce the number of potential bidders, and whether the PLA requirement would otherwise be inconsistent with federal statutes, regulations, executive orders, or presidential memoranda. So those are the bases for granting an exemption. The executive order has not been revoked. People thought perhaps it would be on day one, like so many of the other Biden executive orders, but it was not. However, there was recently a Court of Federal Claims decision holding that certain federal contracts, there are 7 that were challenged under competitive bidding theory in this Court of Federal Claims case. And in that decision, the court held that those 7 federal contracts should not have been procured with a PLA requirement because the requirement was not sufficiently justified through market research. So now they are supposed to go back and decide, the agencies are, whether or not they want a PLA based on market research or based on these factors. So as I say, they have to review their solicitations and come back to the court with a plan for how they ensure to comply. These slides are just on workforce development. So public agencies are often interested in PLAs because they incentivize, facilitate employment of local residents or other targeted demographics. We've talked about that quite a bit. PLAs can promote local hiring in different ways. They can be customized to the desires of the agency, for example, by targeting residents of zip codes or graduates of certain school districts. Some PLAs also establish direct pathways to union apprenticeship from local programs. So here you guys have Valley Build. Do I have that right? Okay. There is a possibility for establishing other pre-apprenticeship programs through project labor agreements. But if you wanted to use a project labor agreement as a workforce development tool, one of the major ways of doing that is basically partnering with local pre-apprenticeship programs to facilitate entry into union apprenticeship. Because otherwise, it can be a little bit tricky getting into union apprenticeship programs. And as we said, the building trades has cohorts that are specifically female. Like you can have a pre-apprenticeship program that is for certain demographics. That's fine. And that's a good way to achieve those equity goals without running afoul of Prop 209. PLAs facilitate employment of local journey persons and apprentices, as I said, potentially through a formal pipeline established via the agreement or through partnerships with local programs. They allow unions to build capacity in their membership and their apprenticeship programs and pre-apprenticeship programs because they know there will be jobs in the future. Like Wyatt was talking about how PLAs are important as ways to lift up the community. But the way the unions can do that is when they know they have a PLA, like we know we have a PLA with the city of Fresno, it's covering a huge amount of work from what I understand, right? We know we're going to have an agreement with State Center. That gives us the ability to bring more people into the trades. That's why it's so important to have these ongoing partnerships rather than a PLA just for a specific project. Because we will feel a lot more confident expanding if we know that there's hours. The trades don't like to bring people into the program and have them sit on the out of work list, right? So we want to make sure that when we're training people in these crafts, that we're going to be giving them jobs, right? And they're going to be making, they're going to be working full time. They're going to be making a family sustaining wage. This is a long-term construction career. And if we're going to do that, especially here in the Central Valley, it's very important to have these ongoing partnerships with public agencies. They also allow for local reputable contractors to compete for public contracts on a level playing field. So getting to the gentleman's point over there about, construction can sometimes really be a race to the bottom because of the low bid system. And because you all as agencies are often constrained by the competitive bidding laws that apply. You have to take the lowest responsive and responsible bid, right? So what does that mean? Maybe in some cases you're actually awarding that contract to the low bidder, but you don't have a lot of confidence in them, right? But if you have a PLA, you know they're going to have to play by the rules. They're going to have to pay people right. They're not going to be able to cheat. They're going to have union reps overseeing the job. So it's just a way to ensure compliance, and it's also a way to make honest, reputable contractors feel like they're going to be able to compete on a level playing field when they're bidding on the project. They also allow local residents, not workers from out of town, to have more money in their pockets, improving the standard of living and generating tax revenue. All right. Any questions? I know we're running late, so I'm fine with just wrapping.
So let's give it up for Jolene.
Yeah. Thank you very much.